Alright people, so welcome to Jumbo IAS and welcome to UPSC Prelims Phoenix batch. In this batch, we revise the entire syllabus for UPSC Prelims examination. Now that includes static as well as current affairs. Both these things would be covered. Now here's the thing. This particular lecture is related to our static lecture series. Okay, and in our static lecture series, we are currently covering Indian polity. Today is day 8 for Indian polity and your today's targets were state executive and state legislature. Now, the notes for these two topics have been already provided to you well in advance. So I'm hoping that you have already gone through the notes and then you are sitting for this lecture. Because when you went through those notes, okay, that was your revision number 1. And this lecture is your revision number 2 because we are going to revise these two topics again through a set of 30 MCQs. All right. So without further ado, without further delay, let's begin our discussion. So let's go. So Indian polity day 8 and these were your today's targets. State executive, because we have covered union executive and union legislature, which was parliament, and state legislature, that is state legislative assembly. Okay, now the first portion of our lecture would be related to state executive, that is mostly related to the role of governor, and then we'll talk about, well, state legislative assembly, state legislative councils, and the topic of state legislature. All right, so let's begin our discussion with question number 1. With reference to qualifications and appointment of governor, consider the following statements. The Constitution mandates that the governor must be a person from outside the state to which he is appointed. Sarkaria Commission recommended that the procedure for consultation with the Chief Minister should be prescribed in the Constitution itself. Vice President of India and the Speaker of Lok Sabha must be consulted by Prime Minister before selecting a governor. Now, here's the thing about as far as the governor is concerned. Now, the role of governor is similar to that of president in a particular state. We all know about this. And Article 155 deals with the appointment of governor. But here's the thing. The governor is appointed by the president and shall remain in office till the pleasure of the president. That means the president can dismiss the governor anytime. That is why the governor kind of acts like the agent of central government. Okay, because central government, by advising the president, can remove the governor anytime. Now, this somehow jeopardizes the constitutional position of the governor because, well, some people might say that the governor won't act in an unbiased way. Okay, he'll be biased towards the ruling party at the center, right? That is why, well, there were various commissions like the Sarkaria Commission. Sarkaria Commission said that amend Article 155 and make it mandatory for the president to take the opinion of state chief minister before appointing the governor, okay, so that an unbiased candidate or unpartisan, okay, non-partisan candidate can be appointed as governor. The Constitution mandates that the governor must be person from outside the state to which he is appointed. The Constitution says no such thing, but generally we appoint a person from outside the state as a governor. Okay, generally we follow this convention, but this is nowhere written in the Constitution. So this is false because it is not the Constitution. Yes, Sarkaria Commission did say that do consult Chief Minister, okay, make it constitutional. Vice President of India and Speaker of Lok Sabha must be consulted by Prime Minister. No such thing is written in the Constitution. Though Sarkaria Commission did give this recommendation that, well, the Prime Minister should consider or consult Vice President and Speaker of Lok Sabha before giving the recommendation to the President for the governor, for the post of governor. Okay, but it is nowhere written, right? So the correct answer is B. Okay, question number 2. Regarding the pleasure of the president, remember pleasure of the president, which means the governor stays in the office till the pleasure of the president. President can dismiss him anytime. In the context of governor's removal, consider the following. In the Surya Narayan versus Union of India case, the Supreme Court held that the president's pleasure in removing a governor is non-justiciable, which means you can't file a case in court that the president dismissed the governor. Well, the dismissal by the president was not right. You cannot question that. The Constitution of India provides specific grounds such as misbehavior or incapacity for the removal of governor. No. The Constitution plainly says pleasure of the president. The president can remove the governor for any reason he chooses. Okay, so this is false, but this is correct. The Supreme Court in this case definitely held that, well, it is not justiciable. The removal is not justiciable. You can't file a case in the court that the governor was dismissed unjusticiably. Okay. So this is correct. The correct answer would be A. Question number 3. Which of the following constitutional provisions or amendments accurately reflects the executive powers of the governor? executive powers of the governor. Okay, the governor appoints the tribal welfare minister in the states of Chhattisgarh, Jharkhand, Madhya Pradesh, and Bihar. 94th Amendment Act 2006 included Odisha in the list of states requiring a tribal welfare minister. The governor can remove the state election commissioner on the grounds of proved misbehavior. The governor appoints the VC, vice chancellors of universities in the state, in his capacity as the chancellor. So, fourth statement is absolutely correct. The governor appoints VCs for different universities, in which he is the honorary chancellor. This is correct. The governor can remove state election commissioner on the grounds of proved misbehavior? No. State election commissioner can be removed on similar grounds as a state high court judge. Okay, so this is not true. Now, as far as these two statements are concerned, well, it is the job of the governor to appoint tribal welfare minister, okay, for the states of Chhattisgarh, Jharkhand, MP, Bihar, Odisha. But Bihar was removed by 94th Amendment Act. Odisha was always there. Bihar was also there. But in 2006, Bihar was removed from this list. So both these statements are false. The answer would come out to be D. Okay, next. Consider the following statements regarding the legislative powers of the governor. The governor can nominate one member from Anglo-Indian community to State Legislative Assembly under Article 333. Okay. If the offices of both Speaker and Deputy Speaker fall vacant, the governor can appoint any member of Assembly to preside over the proceedings. The governor decides on the disqualification of members of state legislature in consultation with the High Court. Okay. Now, earlier, before 2019, well, the president used to appoint two members from the Anglo-Indian community to Lok Sabha, and the governor used to appoint one member from Anglo-Indian community to State Legislative Assembly. But this provision was done away with by a Constitutional Amendment Act in 2019. So currently, this is not true. Yes, if the offices of both Speaker and Deputy Speaker lie vacant, either because of death or resignation or anything, then the governor can appoint any member of the assembly to preside over. The governor will appoint till further elections for new Speaker and Deputy Speaker take place. Yes. Okay. Now, like president decides on the disqualification of MPs, similarly, governor also decides on the disqualification of MLAs. But for that, both of them, president and governor, have to take the opinion of Election Commission of India, not High Court. Okay, so the answer to this question again would be B. Okay, next. In which of the following scenarios is it obligatory for the governor to reserve a bill for the consideration of the president? Now look, generally, any bill that is passed by state legislature will become a law after it receives the assent of the governor, right? And generally, governor's position is also similar to that of president, but governor has one extra power. Governor can reserve any bill for the consideration of the president. Okay, if president gives his assent, then only that bill will become a law. Now, the thing is that which bill shall be reserved by the governor for president, that is up to the governor. But there is one category of a bill, one category in which the governor has to reserve the bill. Okay, in other categories, it is up to the governor. But there is one particular kind of bill in which the governor has to reserve that bill for the president. And that is, if the bill passed by state legislature endangers the position of state high court, if this new bill reduces the powers of state high court or anything, that bill has to be reserved for the president. Okay. In other cases, the choice is with the governor. He can, may or may not reserve the bill for the president. Okay, and nobody can question that reservation also. Nobody can question it. Okay, and this has been, this was the recent controversy between Tamil Nadu governor and Tamil Nadu chief minister also, because the Tamil Nadu governor was reserving bills for president's consideration and delaying them permanently. Okay, C. Next. With reference to governor's ordinance making power. The ordinance making power is with the president, as well as in state's case, it is with governor, and it is temporary law making power. We all know about this. The governor can promulgate an ordinance even when one of the two houses of a bicameral legislature, states where there are two houses, legislative assembly, legislative council, is in session. An ordinance ceases to operate 6 months after reassembly of the state legislature unless disapproved earlier. The governor requires prior instructions from the president to issue an ordinance if a similar bill would have required the president's previous sanction. Okay. Now, first statement is correct. even if one house is not in session, the governor can promulgate an ordinance. Okay. An ordinance ceases to operate 6 weeks, not 6 months. Okay. The governor, now there are certain categories of bills that can only be introduced in a state legislative assembly after receiving the previous sanction of the president. Previous approval of the president is required to even introduce that bill. If governor is making an ordinance related to that bill with similar provisions, okay, then in that ordinance, you have to take prior permission of the president as well. So this is definitely correct. Answer would come out to be 1 and 3. Okay, next. We have already discussed this in the chapter of president. Compare the pardoning powers of the president and the governor. Which of the following is true? Both the president and governor can pardon a death sentence. Not at all. President can pardon a death sentence, not governor. Governor cannot suspend, remit or remit a death sentence. Only the president can. Now, the governor cannot pardon a death sentence, but he can suspend, remit, commute a death sentence. So this is also false. The governor can grant pardon for offences against state laws, while the president's power extends to both central and state laws. Absolutely correct. Okay. The governor has the power to grant pardon in case of court martial. No, president does. So C. Okay. Next. Consider the following statements regarding discretionary powers of the governor. Discretionary means where he is not bound by the aid and advice of State Council of Ministers. Okay. Unlike the president, the governor's discretionary actions are protected from being questioned in court on the grounds that he ought not to have acted in his discretion. 42nd Amendment made ministerial advice binding on both the president and the governor. Governor has situational discretion to dismiss council of ministers if they lose no confidence vote in legislative assembly. So this part is definitely correct. If they lose no confidence vote, the president can dismiss anytime if he wants, dismiss the government. Now, by 42nd Amendment Act, Article 74 was amended and it made it mandatory for the president to follow the advice of Prime Minister and Council of Ministers. But no such provision was made for governor to follow state chief minister and his council of ministers. Okay. So unlike the president, the governor's discretionary powers are protected from being questioned. The president cannot act outside the aid and advice. Okay, mostly. But the governor can, and if the governor is using his discretionary powers, nobody can question it. The constitution is very clear. In certain cases, governor can use his discretion, not bound by aid and advice. And which cases are those where the governor can use his own choice? Well, nobody can question that in a court of law. So this is true. Okay. The 42nd Amendment made ministerial advice binding on just the president. No such provision was made for the governor. Okay. So the answer would come out to be 1 and C. Right. Next. Governor has special responsibilities to discharge according to directions issued by the president. Match the following pairs. Now, governor has certain special responsibilities, okay, where he's bound by the directions issued by president. He's not bound by chief minister, aid and advice of chief minister. The constitution gives the governor some special responsibilities where he is not bound by the aid and advice of chief minister. Match the following. Nagaland, administration of tribal areas. Gujarat, establishment of separate development boards for Saurashtra and Kutch. Maharashtra, law and order. Okay, now listen to me carefully. For Nagaland, governor's responsibility is law and order. For Gujarat, yes, establishment of development boards for Saurashtra and Kutch, yes. For Maharashtra, establishment of special development boards for, well, Vidarbha. Okay, for Vidarbha, special development boards. For law and order, governor's responsibilities extend to Nagaland and Arunachal. Okay, so only 2 is correct. Okay, next.